Technology?
Everything seems to work.
Okay. Yeah, I'm gonna take mine. Yep. Did you want me to correct first? Just prior to the witness or the witness? Is everybody in?
Yes, Your Honor.
All right, bring in the jury.
All right, woman. All rise for the jury. Please be seated. Your Honor, the jury is all present and accounted for.
All right. We are on the record in C-377239, State of Nevada versus Devyn Michaels. May the record reflect that Ms. Michaels is present with her attorneys, deputy district attorneys, on behalf of the state. Do both parties stipulate to the presence of our jury?
Yes, Your Honor.
All right, and are you guys ready to begin?
Yes, Your Honor.
Yes.
All right, ladies and gentlemen, before we begin this trial, for those of you who are going to be our jurors, I want to let you know what to expect. So we're going to go through some preliminary instructions before we get started. First of all, we'd like you to be as comfortable as possible while you're here. So if you have any trouble hearing or seeing at any time during this trial, please raise your hand as an indication. Also, if you need to use the restroom, if you feel ill, or if you have any other problem, please also raise your hand and let us know. I also encourage you to stand up and stretch between witnesses, or when the attorneys are discussing something at the bench with me. You can also feel free to bring in water or anything or a drink, as long as it doesn't cause any disruption in the proceedings. During this trial, we will generally meet between 9 o'clock and end around 5. Occasionally, we may break shortly after 5 if there's a witness testifying at that time or a witness who needs to be called out of order, but we will not stay past 6. Also, during the day, we will generally break for lunch between 11:45 and 1 o'clock, depending on what time we started, and we will break for about an hour and 15 minutes, and then we'll have a break in the afternoon for about 15 minutes. This is a criminal case commenced by the state of Nevada, which I may sometimes refer to as the state, against Devyn Michaels. This case is based on the second amended indictment. The clerk will now read the second amended indictment to the ladies and gentlemen of the jury and state the plea of the defendant to that second amended indictment.
District Court, Clark County, Nevada, the state of Nevada plaintiff versus Devyn Jade Michaels, aka Nikki Fairchild, aka Tracy Baker, aka Tracy Nicole Tavares, defendant, case number C-23377-239-1, Department 10, third amended indictment, State of Nevada, County of Clark, the defendant above named, Devyn Jade Michaels, aka Nikki Fairchild, aka Tracy Baker, aka Tracy Nicole Tavares, accused by the Clark County Grand Jury of the crime of murder with use of a deadly weapon, committed at or within the County of Clark, State of Nevada, on or about the 7th day of August 2023 as follows. Did willfully, unlawfully, feloniously, and with malice aforethought kill Johnathan Willette, a human being with use of a deadly weapon, to wit, a wooden stick and/or other unknown object, by striking the said Johnathan Willette with said wooden stick and/or other unknown object, and/or through other unknown means, the said killing having been 1, willful, deliberate, and premeditated, and/or 2, committed during the perpetration or attempted perpetration of a robbery. Dated this 28th day of October 2025, Stephen B. Wolfson, Clark County District Attorney, by John Giordani, Chief Deputy District Attorney, to which the defendant has pled not guilty to.
Ladies and gentlemen, please understand that the second amended indictment is simply a charge and that it is not in any sense evidence of the allegations it contains. The defendant has pled not guilty to the second amended indictment. The state therefore has the burden of proving each of the essential elements of the second amended indictment beyond a reasonable doubt. As the defendant sits there now, she's not guilty. The purpose of this trial is to determine whether the state will meet that burden. It is your primary responsibility as jurors to find and determine the facts. Under our system of criminal procedure, you are the sole judge of the facts. You are here to determine the facts from the testimony you hear and other evidence, including exhibits introduced in court. It is up to you to determine the inferences which you feel may be properly drawn from the evidence. Ladies and gentlemen, you must base your verdict solely on the evidence presented in the courtroom and the instructions from the law that I give to you. To protect the integrity of the jury process, it is very important that you do not do any independent research about this case until the jury has reached a verdict. Ladies and gentlemen, there is a lot of media coverage in regards to this case, but it's very important that you do not watch any media coverage of this case, or you do not do any additional media searches on your own about this case. You may not visit any location involved in this case. You must not do any research or look up words, names, maps, or anything else that may have anything to do with this case. This includes any reading of newspapers, watching television, or using a computer, cell phone, the internet, or any other means to get information related to the case or the people and places involved in the case. This applies whether you're in the courthouse, at home, or anywhere else. Additionally, until you are discharged from your service as a juror, you must not provide or receive any information about your jury service to anyone, including your friends, co-workers, and family members. You may tell people you've been picked for a jury and how long the case will take. However, you must not give any information about the case itself or the people involved in the case. You must also warn people not to try to say anything to you or write to you about your jury service, or write to you about this case. This includes face-to-face, phone, or computer communications. In this age of electronic communication, I want to stress that you must not use electronic devices or computers to research or talk about this case. This includes Googling, tweeting, texting, blogging, emailing, posting information on a website, or any other means at all. All of us are depending on you to follow these rules so that there will be a fair and lawful resolution to this case. You may not declare to your fellow jurors any facts relating to this case of your own knowledge. And if you discover during the trial or after the jury has retired that you or any other juror has personal knowledge of any witness or fact in controversy in this case, you must disclose that information to me outside the presence of the other jurors. The evidence in this case will consist of sworn testimony of witnesses, all exhibits received in evidence, regardless of which side introduces the evidence. If the attorneys on both sides stipulate to the existence of a fact, you must, unless otherwise instructed, accept the stipulation as evidence and regard that fact as proven. I may take judicial notice of certain facts or events. If I take judicial notice of a fact or event, you must accept that fact as true. In every case, there are two types of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what the person saw or heard or did. Circumstantial evidence is testimony or exhibits which are proof of a particular fact, from which if that fact is proven, you can infer the existence of a second fact. For example, if you're outside and you see and feel raindrops falling on you, that's direct evidence that it's raining because you can feel and see the raindrops fall on you. But if you go to sleep at night and the ground is dry, but when you wake up in the morning the ground is all wet and there are puddles outside, that is circumstantial evidence that it rained while you were asleep. Although you didn't see it raining, you know the ground was dry when you went to sleep, and now it is wet, and that is circumstantial evidence that it rained last night. You may consider both direct and circumstantial evidence in deciding this case. The law permits you to give equal weight to both types of evidence, but it is up to you to decide how much weight to give to a particular piece of evidence. The parties may sometimes make objections to some of the testimony or other evidence. It is the duty of a lawyer to object to the evidence which he or she believes may not properly be offered, and you should not be prejudiced in any way against a lawyer who makes objections on behalf of the party he or she represents. At times, I may sustain objections or direct that you disregard certain testimony or exhibits. You must not consider any evidence to which an objection has been sustained or which I've instructed you to disregard. You also must not consider anything which you may have seen or heard when court is not in session, even if what you see or hear is said or done by one of the parties or by one of the witnesses. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, if any, the relation of the witness to the defendant or the state, the inclination of the witness to speak truthfully or not, and the probability or improbability of the witness's statements and all of the facts and circumstances and evidence. Thus, you may give the testimony of any witness just such weight and value as you believe the testimony of the witness is entitled to receive. After these instructions, we'll have an opening statement by the state, maybe an opening statement by the defense, the state's evidence, the defense's evidence if they desire to present any evidence, jury instructions, and closing arguments. Opening statements and closing arguments are intended to help you in understanding the evidence and applying the law, but please understand that what the attorneys tell you is not evidence. At the conclusion of the evidence, I will instruct you on the law. You must not be concerned with the wisdom of any rule of law stated in these instructions or the instructions that I will read to you after the evidence is in. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given to you by the court. Until the case is submitted to you, you must not discuss it with anyone, not even with your fellow jurors. After it's submitted to you, you must discuss it only in the jury room with your fellow jurors. It is important that you keep an open mind and not decide any issue in the case until the entire case has been submitted to you under instructions from me. Again, if you discover during the course of the trial that you have personal knowledge of the facts of the case, or that you know one of the witnesses, please give a note to the marshal who will present it to me. During this trial, it may be necessary for me to confer with the lawyers at the bench about questions of law or procedure that I need to make a decision on. Sometimes you may be excused from the courtroom for the same reason. I will try to limit these interruptions as much as possible. Please understand if we take a break, it is necessary, and we appreciate your patience. You will be given a badge to wear during your jury service. Please wear the badge at all times while you're in the courthouse or on a break. This badge lets everyone know that you're a juror in this case. This is important because during the course of this trial, the attorneys for both sides and court personnel, other than the marshal, are not permitted to talk to members of the jury. By this, I mean not only can they not talk to you about the case, they can't talk to you at all, not even to ask you what time it is. This badge helps them identify you as a juror. If someone will not talk to you, please understand that they are not being rude. To ensure the absolute impartiality of the jury, the people involved in the case are bound by ethics and law to avoid contact with jurors until the case is decided. You've also been given papers and pens for your use. You are free to take notes during the trial if you wish, but please keep the notes to yourself until you and your fellow jurors go to the jury room to decide the case. Do not let note-taking distract you. You should also rely on your own memory of what was said and not be overly influenced by the notes of other jurors. If jurors have conflicting notes, you should not rely on the notes because the court recorder's record contains a complete and authentic record of this trial. I will also type my own notes during trial. Please do not take this into consideration. If I begin to type during a witness's testimony, you are not to consider that testimony any more important than any other testimony. In fact, you're not to consider anything I say or do during this trial to suggest that I'm inclined to favor the claims or position of either party. I'm required to remain neutral. It would be wrong for you to conclude that anything I say or do means I'm for one side or another in this trial. Discussing and deciding the facts is your job and your job alone. Jurors are allowed to ask questions. The procedures require that you write your juror number and question on a full sheet of paper and give it to the marshal while the witness is still in the courtroom. Questions must be factual in nature and designed to clarify information already presented. If it's a proper question under the court rules, I'll ask it. If the evidence rules prevent me from asking the question, then I won't ask the question. If I don't ask a question, I'll keep the question and explain after trial the purpose of the rule that precluded me from asking it. Please reserve your questions until the attorneys have finished asking questions of the witness, as the attorneys will likely ask your question. Jurors must not place undue weight on the responses to their questions or draw any conclusion because the questions was not asked. There may be some testimony in this case that will be given through an interpreter. An interpreter will provide a translation for you at the time the testimony is given. You must rely on the translation provided by the interpreter, even if you understand the language that's spoken by the witness. Do not retranslate any testimony for other jurors. If you believe the court interpreter translated testimony incorrectly, let me know immediately by writing a note and giving it to the marshal prior to the witness being excused from the courtroom. Finally, in fairness to the parties to this case, you should keep an open mind throughout this trial, reaching your conclusion only during your final deliberations after all the evidence is in and you've heard the attorney's closing arguments and my instructions to you on the law. Now that I've given my preliminary instructions, the clerk will now administer the oath to the members of the jury. Ladies and gentlemen, will you please rise and raise your right hand so that the clerk can administer the oath.
You and each of you do solemnly swear that you will well and truly try the case at issue and a true verdict render according to the evidence, so help you God. You may be seated. Thank you.
Thank you all. State, are you prepared to give an opening statement?
Yes, Your Honor. Thank you.
Prior to that, can counsel approach?